right, ma'am, you're Victavia Sanders.
Yes, ma'am.
And Ms. Sanders was previously here in cause number 22-39884. Entered pleas are true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved of.
Before proceeding, a quick note is necessary. This explanation is provided strictly for educational purposes, intended to guide those seeking clarity on courtroom procedure. If it does not serve your interest, feel free to move on. For those looking to understand the legal process, pay close attention. This is not an ordinary sentencing hearing. A defendant already on felony probation now faces a new theft allegation, with body camera footage substituting for live testimony. The judge clearly recalls offering a prior second chance, which may now be revoked. Observe carefully because this case highlights accountability, credibility, and the consequences when the court believes the defendant acted with knowledge of wrongdoing. The stakes are significant, and each decision from this point carries tangible legal consequences.
And that was going to be my issue with the pre-sentence report. The court's Mr. Smith was prepared to prove that. And
Okay, let's go through that.
The necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
He's got to play the video.
I'm coming from the pocket side. 244 on the mirror.
On patrol 115-826 cars.
On that door? That's her scooter. Oh, I know that.
Actors are going to the car, so I'm trying to leave on the door.
Hey, stop. You're being detained? Man in the back, please come up here. Hey, you're being detained, okay? Okay, we'll worry about that in a second. Just come over here so we can talk. Okay, so you're not under arrest, you're just detained. And so, I thought she was just taking her now. She just took everything out and dumped it on the floor back there. Put your hands back there. And just stay here. Do you have any other merchandise on you, person? Anything illegal?
They can take this, I got it, I got the stage. Yeah, we did, I watched you on the camera. What? Watching you on the entire time.
What we're doing, look, if you have anything illegal, look at me. Hey, just look at me. If you have anything that you didn't buy, just send it on the camera.
Can you text this out from the phone?
Not at the moment, no, because
I'm talking about.
where you're acting like a fool.
Oh, no, I'm not gonna do
You
this.
act like
I
a fool.
promise I'm not.
Just like I said, just put it all right here. Nothing else in your pockets or anything?
No.
All right, let me.
All right, any other evidence with regard to count one?
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
This moment represents a decisive legal question. The defense challenges the evidence, citing a warrantless search. However, the key legal distinction lies in how the evidence was obtained. The officers did not physically search the defendant. She voluntarily surrendered the items following their directive. That difference is critical in law. There is no custodial interrogation, no Miranda violation, and no compelled search. For these reasons, the judge overrules the objection and rules the allegation true. Consider this. If you were detained but not formally arrested, would you understand when you have the legal right to refuse? And would your response differ in the same situation?
All right, any evidence with regard to count one before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and so,
Followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object if that's an illegal search.
All right, that objection's overruled. I am going to find count one true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true, count 2. Again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage now that the state has offered evidence as to count, as to be a new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would again defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know. It's not really-
With the pending charge of this theft, she's not eligible to go to ISF.
If I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony court.
It's here, it's mine.
Okay.
Because it's a prior thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated report?
Everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like, me being away from my kids right now is really hard, because they be with my mama, and my mama had dementia, and she...
Stop with everybody else, because I'm not gonna make my decision today based on the fact that you have kids, or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No.
that if I send you to prison, that I'm somehow gonna be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was gonna happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. Some point, you have to stop. Anything else?
Judge, even based on what you told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
Violence is my responsibility.
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, if you're in there doing it, you are the wrong person, right? So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to...
I'll get the other one worked out today.
Okay, I'll hold it while y'all do that, and then while I'm doing that, I need I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. Sanders.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Sanders, in cause number 25, DCCR 1351, you're charged with the state jail felony offense of theft of property with previous convictions, and that is from July 31st of 2025. The indictment alleges you were previously convicted of theft November 13th of 2017, and then again April 15th of 2019. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have some documents here on the tablet. I guess it's coming. The documents on the tablet, they have your signature on them that the state's marked as exhibit number 1. Did you go over those documents with Mr. Kenmore?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Why is it less than what I just
Cost of
did?
back time, maybe, I think it's cost back time in the case.
All right.
So the back, so it lines up on the release date.
It's Christmas.
It's Christmas also.
We'll go with that. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Sanders is not competent?
Well, there's none, to my knowledge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of theft with prior convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It will run concurrently, which means that they're together at the same time with the other case. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I want to make sure you understand, don't go do this time and get out, keep doing the same things, because it can get worse. Today, what could have happened is...
To summarize the ruling clearly, the court finds sufficient evidence, revokes probation, and imposes state jail time. At the same time, the new theft case is resolved concurrently, preventing consecutive sentences that could have dramatically increased the punishment. This decision demonstrates both consequence and judicial restraint. The judge underscores the risks of repeated offenses, the limits imposed by law, and the reality that continued violations lead to harsher penalties. For viewers, this case illustrates not only legal procedure, but also the reasoning behind judicial decisions. If this breakdown was insightful, make sure to like, comment your thoughts, and subscribe for more in-depth courtroom analyses explaining both the actions and the legal rationale behind them.
The new case could have actually been stacked on top of the other case. I could have given you up to 24 months on one and then stacked the other. So you already know now, we're not playing games. You've got to stop, okay? All right. You go back with the
Your Honor, for the record, as part of the plea bargain, she's waiving appeal on F-22-39884. She's
Okay.
waiving appeal.
Thank you, Mr. Kimler. All right, you can go back with the bailiff. Again, you're Jacoby Frazier?
Yes, ma'am.
So, Mr. Frazier, I gave you an opportunity to visit with Ms. Holmes about your case. You had already entered a plea of guilty before, and we had come back for sentencing, and then I wanted you to visit with that doctor to make sure that you understood everything.
No, I understand.
And so, do you want me to go forward with your sentencing today and give you that probation that y'all talked
Yes,
about? Any issues, Mr. Coleman?
No, Judge.
So, Mr. Frazier, I'm going to follow the agreement that you made previously with the district attorney. Find that you entered your plea freely and voluntarily. Again, find that you are mentally competent. Sentence you in accordance with that agreement. I'm going to defer all proceedings for a period of 4 years. You will be ordered to pay a $500 fine, and you're going to be ordered to follow all of the rules and conditions of probation. Part of those conditions are that you follow through with any treatment for mental health care through Spindletop. So if there's classes or counseling or medication, whatever it is, that's now not just part of what you probably need to do, but it's part of your probation. You understand?
Yes, ma'am.
So if you don't go to your appointments at Spindletop and you don't take your medicine like you're supposed to, then it could end up with your probation getting revoked, and you could go to prison for up to 10 years. Do you understand?
Yes, ma'am.
So it's very important that you do everything your probation officer tells you. Okay? So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Obviously, it needs to be on the mental health caseload as well. Yeah, it was already done. And so you'll be released from jail today. It's very important that the first thing you do is go to the probation department. The probation officer is going to talk to you today here in court. She's going to tell you where you need to go, and you need to make sure you try to get there today, okay?
I will.
Okay, good luck. You can go back with the bailiff.
And I have the paperwork where the probation.
She's going to give it all to you. She's going to give it to you. You'll have everything in writing.
Thank you, Ms. Harmon.
You're welcome.
Thank you, Judge West.
Yes, sir. You're welcome. Happy holidays. Merry God bless.
Hey, Judge West.
Good morning. You're Jacoby Frazier.
Yes, ma'am.
And Mr. Frazier, it was evaluated for competency to stand trial by Dr. Pond in cause number 25 DCCR 0732. I've received that report and will take judicial notice of the court's file. Excuse me. That report is dated November 3rd of 2025. The finding is that Mr. Frazier is competent to stand trial.
Yes, ma'am.
And is there any other evidence with regard to competency?
No, Your Honor.
Not from the state yet.
All right, then at this time, I will make the finding that Mr. Frazier is competent to stand trial. And then, Ms. Holmes, do you need some time to get out and visit with him with that? And
I do know that last time we did have a plea agreement. I believe we had done the paperwork, but then there were some issues where he was needing to be examined.
okay, if y'all want to attempt that, I can hold it. If you want to try to go through it today, then we can take all that into consideration and see if we can get there.
Yes, ma'am.
Okay.
Yeah, I'll try to do that.
Okay, I'll hold it to see if we can get it taken care of. And if you need more time, just let me know.
You're gonna talk to me today?
You still have the paperwork? Hold on. Do you want to talk to him for a minute first? And then,
Yeah, let me.
okay,
check
go ahead and
real quick.
send it, but
Yeah.
y'all visit and I'll hold it for a second.
Okay.